Today I am talking about fundamental rights and fundamental duties. This is the third part of fundamental rights and fundamental duties. State action in this context must, however, be understood in a wider sense for interpreting the words state wherever it occurs in the part on fundamental rights. A definition has been given in Article 12, which says that unless the context otherwise requires, the state will include not only the executive and legislative organs of the union and state, but also local bodies such as municipal authorities as well as other authorities. This latter expression refers to any authority or body of persons exercising the power to issue orders, rules, bylaws, or regulation having the force of law. As for example, a board having the power to issue statutory rules for exercising governmental powers. Even the fact of a private individual may become an act of the state if it is enforced or aided by any of the authorities just referred to. It should be noted, however, that there are certain rights included in Part 3 which are available not only against the state but also against private individuals. For example, Article 51, Clause 2, equality in regard to access to and use of places of public resort. Article 17, prohibition of untouchability. Article 18, 3 to 4, prohibition of acceptance of foreign title. Article 23, prohibition of traffic in human beings. Article 24, prohibition of employment of children in hazardous employment. But these provisions in Part 3 are not self-executory. That is to say, these articles are not directly enforceable. They would be indirectly enforceable. Only if some law is made to give effect to them and such law is violated, it follows that classification of fundamental rights, not executory and self-executory, is another possible mode of classification. We may now proceed to a survey of the various fundamental rights. In particular, Article 14 of the Constitution provides the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. We must know about the Article 14 of our Constitution, which provides the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. This is very important. Prima facie, the expression equality before the law and equal protection of the laws may seem to be identical, but in fact they mean different things. While equality before the law is a somewhat negative concept, implying the absence of any special privilege by reason of birth, creed, or the like in favor of any individual, and the equal subjection of all classes to the ordinary law. Equal protection of law is more positive concept, implying the right to equality of treatment in equal circumstances. The concept of equality and equal protection of laws in its proper spectrum encompasses social and economic justice in a political democracy. Equality before law, as a student of English constitutional law knows, it is the second corollary from Dicey's concept of the rule of law. Equality before law is correlative to the concept of rule of law for all-round evaluation of healthy social order. It means that no man is above the law of the land and that every person, whatever be his rank or status, is subject to the ordinary law and amenable to the jurisdiction of any ordinary tribunal. Against every citizen, from the Prime Minister down the humblest peasant, a is under the same responsibility for every act done by him without lawful justification, and in this respect there is no distinction between officials and private citizens. It follows that the position will be the same in India. But even in England, certain exceptions are recognized to the above rule of equality in the public interest. The exceptions allowed by the Indian Constitution are: the president or the governor of the state shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those powers and duties. No criminal proceeding whatsoever shall be instituted or continued against the president or a governor in any court during his term of office. No civil proceeding in which relief is claimed against the president or the governor of the state shall be instituted during his term of office in any court in respect of any act done or purporting to be done by him in his personal capacity, whether before or after he entered upon his office as president or governor of such state, until the expiration of 2 months next after notice in writing has been delivered to the president or the governor, as the case may be, or left at his office, stating the nature of proceedings, the cause of action, therefore the name, description, any place of residence of the party by whom such proceedings are to be instituted, and the relief which he claims. Article 361. The above immunities, however, shall not bar the impeachment proceeding against the president, suits or other appropriate proceedings against the governor of India or the governor of a state. Besides the above constitutional exceptions, there will of course remain the exceptions acknowledged by the Committee of Nations in every civilized country, as for example, in favor of foreign sovereigns and ambassadors, equal protection of laws. Equal protection of laws, on the other hand, would mean that among equals the law should be equal and equally administered, that like should be treated like. Equal protection requires affirmative action by the state towards unequals by providing facilities and opportunities. In other words, it means that right to equal treatment in similar circumstances, both in the privileges conferred and in liabilities imposed by the law. None should be favored and none should be placed under any disadvantage in circumstances that do not admit of any reasonable justification for a different treatment. Thus, it does not mean that every person shall be taxed equally, but the persons under the same character should be taxed by the same standard. But if there is any reasonable basis for classification, the legislature would be entitled to make a different treatment. The legislature is competent to exercise its discretion and make classification. It is for the legislature to identify the class of the people to be given protection and on what basis such protection was to be given. The court cannot interfere. A state has wide discretion in respect of the classification of objects, persons and things for the purposes of taxation. The legislature can devise classes for the purpose of taxing or not taxing, exempting or not exempting, granting incentives and prescribing rate of tax, benefits and concessions. Thus, it may first exempt certain classes of property from taxation at all, such as charities, libraries, and like. Impose different specific taxes upon different trades and professions, tax real and personal property in different manner, and so on. The guarantee of equal protection thus is a guarantee of equal treatment of persons in in equal circumstances, permitting differentiation in different circumstances. In other words, the principle of equality does not mean that every law must have universal application for all persons who are not by nature, attainment, or circumstance in the same position, as the varying needs of different classes of persons often require separate treatment. The principle does not take away from the state the power of classifying persons for legitimate purposes. A legislature which has to deal with diverse problems arising out of an infinite variety of human relations must of necessity have the power of making special laws to attain particular objects, and for that purpose it must have large powers of selection or classification of persons and things upon which such law are to operate. In order to be reasonable, a classification must not be arbitrary but must be rational. That is to say, it must not only be based on some qualities or characteristics which are to be found in all the persons grouped together and not in odd others who are left out, but those qualities or characteristics must have a reasonable relation to the object of legislation. The reasonableness of a provision depends upon the circumstances obtaining a particular time and the urgency of the evil sought to be controlled. The possibility of the power being abused is no ground for declaring a provision violative of Article 14. In order to pass the test, two conditions must be fulfilled, namely that first, classification must be founded on an intelligible differentia which distinguishes those that are grouped together from others, and second, that differentia must have a rational relation to the object sought to be achieved by the act. It is not possible to exhaust the circumstances or criteria which may accord a reasonable basis for classification in all cases. It depends on the sub-object of the legislation in view, and whatever has a reasonable relation to the object or purpose of the legislation is a reasonable basis for classification of the persons or things coming under the purview of the enactment. Thus, the basis of classification may be geographical. The classification may be according to difference in time. The classification may be based on the difference in the matter of the trade, calling, or occupation which is sought to be regulated by the legislation. Similarly, higher educational qualification is a permissible basis of classification for promotion, as it has nexus with higher efficiency on the promotional post. Thus, it has been held that in offences relating to women, adultery, women in India may be placed in a more favorable position having regard to their social status and need for protection. In the law of prohibition, it would not be unconstitutional to differentiate between civil and military personnel or between foreign visitors and Indian citizens, for they are not similarly circumstanced from the standpoint of need for prohibition of consumption of liquor. Exemption to the candidate who stood first in the Forest Rangers College from selection as assistant conservator by the Public Service Commission, it being based on reasonable qualification, it not ultra vires Article 14. The guarantee of equal protection applies against substantive as well as procedural laws. The decision-making process should be transparent, fair, and open. The procedure for distribution of state largesses must be transparent, just, fair, and non-arbitrary. Non-transparency promotes nepotism and arbitrariness. Hence, the discretion vested by the statute is to be exercised fairly and judicially and not arbitrarily, but subject to the requirements of law. In the absence of rules, the action of government is required to be fair and reasonable. From the standpoint of the latter, it means that all litigants who are similarly situated are able to avail themselves of the same procedural rights for relief and for defense without discrimination. Of course, if the differences are of a minor or of unsubstantial character which have not prejudiced the interest of the person or persons affected, there would not be a denial of equal protection. Again, a procedure different from that laid down by the ordinary law can be prescribed for the particular class of persons if the discrimination is based upon the reasonable classification having regard to the object which the legislation has in view and the policy underlying it. Thus, in a law which provides for the externment of undesirable persons who are likely to jeopardize the peace of the locality, it is not an unreasonable discrimination to provide that a suspected person shall have no right to cross-examine the witness who depose against her. For the very object of the legislation, which is an extraordinary one, would be defeated if such a right were given to the suspected person. In the reference on the Special Courts Bill 1978, the Supreme Court has held that the setting up of a special court for the expeditious trial of offences committed during the emergency period from 25/6/1975 to 27/3/1977 by high public officials in view of the congestion of work in the ordinary criminal courts and in view of the need for a speedy termination of such prosecutions in the interest of the functioning of democracy under the Constitution of India as a reasonable classification. But to include in bill any offence committed during any period prior to the proclamation of emergency in June 1975 was unconstitutional inasmuch as such classification has no reasonable nexus with the object of the bill. The guarantee of the equal protection includes absence of any arbitrary discrimination by the laws themselves or in the matter of their administration. Thus, even where a statute itself is not discriminatory, but the public official entrusted with the duty of carrying it into operation applies to against an individual not for the purpose of the act but intentionally for the purpose of injuring him. The latter may have that executive act annulled by the court on the ground of contravention of the guarantee of equal protection. Of course, it is for the aggrieved individual to establish beyond doubt that the law was applied against him by the public authority with an evil eye and an unequal hand. In short, Article 14 hits arbitrariness of state action in any form. An act which is discriminatory is liable to be labeled as arbitrary. The court will not interfere in the policy decisions of the government unless the government action is arbitrary or indivisiobly indiscriminatory. The government policy is not subject to judicial review unless it is demonstrably arbitrary, capricious, irrational, discriminatory, or violative of constitutional or statutory provisions. In the duty of a state to allay fears of citizens regarding discrimination and arbitrariness, however, protective discrimination in favor of Supreme Courts and in favor of scheduled castes and scheduled tribes is a part of constitutional scheme of social and economic justice to integrate them into the national mainstream so as to establish an integrated social order with equal dignity of persons. Relation between Article 14 to 16, as the Supreme Court has observed, Articles 14 to 16 taken together enshrine the principle of equality and absence of discrimination. While the principle is generally stated in Article 14, which extends to all persons, citizens or aliens, Article 15 and 16 deal with particular aspect of that equality. Thus, Article 15 is available to citizens only, and it prohibits discrimination against any citizen in any matter at the disposal of the state or any of the specified grounds, namely religion, race, caste, sex, or place of birth. Article 16 is not confined to citizens, but it is restricted to one aspect of public discrimination, namely employment under the state. In matters not coming under Article 15 and 16, if there is any discrimination or validity of that can be challenged under the general provision in Article 14. As just stated, a particular aspect of the equality guaranteed by Article 14 is the prohibition against discrimination contained in Article 15 of the Constitution, which runs thus. The state shall not discriminate against any citizen on ground only of religion, race, caste, sex, place of birth, or any of them. No citizen shall on ground only of religion, race, caste, sex, place of birth of any of them, subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. Nothing in this article shall prevent the state from making any special provision for women and children. Nothing in this article in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and the scheduled tribes. It will be seen that the scope of this article is very wide. While the prohibition in clause 1 is labeled against state action, the prohibition in clause 2 is labeled against individuals as well. Clause 1 says that any act of state, whether political, civil, or otherwise, shall not discriminate as between citizens on grounds only of religion, race, caste, sex, place of birth, or any of them. The plain meaning of this prohibition is that no person of a particular religion, caste, etc. shall be treated unfavorably by the state when compared with persons of any other religion or caste merely on the ground that he belongs to the particular religion or caste, etc. The significance of the word only is that if there is any other ground or consideration for the differential treatment besides those prohibited by this article, the discrimination will not be unconstitutional. Thus, discrimination in favor of a particular sex will be permissible if the classification is the result of other consideration besides the fact that the persons belong to that sex, as for example physical or intellectual fitness for some work. For instance, women may be considered to be better fitted for the jobs of a nurse, while they may not be considered eligible for employment in heavy industries like steel factory. Such discrimination being based on a ground other than sex would not be considered to be unconstitutional. But if a person is sought to be discriminated against simply because he belongs to a particular community, race, or sex, he can get the state action annulled through a court. While racial discrimination still persists as a malignant growth upon Western society, it speaks volumes of Indian achievement that a possible victim of racial discrimination in India can obtain relief direct from the highest court of the land by means of a petition for an appropriate writ, and yet no such complaint has so far come before the courts. As already stated, in regard to the public places specified in clause 2, the protection is available even against discriminatory act by private individuals. Clause 2 provides that so far as places of public entertainments are concerned, no person shall be subjected to discrimination on the grounds only of religion, race, caste, sex, place of birth, or any of them. Whether such discrimination is the result of an act of the state or of any other individual, even wells, tanks, bathing ghats, roads, and places of public resort which are owned by private individual are subject to this prohibition, provided they are maintained wholly or partly out of the state funds, or they have been dedicated to the use of general public. The above prohibition against discrimination, however, would not preclude the state from making special provisions for women and children, making special provision for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and scheduled tribes. This is all about today's fundamental rights and fundamental duties. Thanks, regards.